Hello everyone, so we are now going to cover involuntary manslaughter part 2, and I'm going to take you through the requirements for gross negligence manslaughter and then reckless manslaughter. So we're going to first start with gross negligence manslaughter, and as some of you already know, this offence derives from the civil concept and the civil area of the tort of negligence, where you could sue somebody in the civil courts for breaching their duty of care to you. And of course, for a claimant, they would have to make out and satisfy the court that the defendant owed them a duty of care, and they then breached that duty of care. And that breach led to the causing of some foreseeable harm or damage. And if the civil court was satisfied, then they would pay out compensation to the claimant. Of course, it would be for the defendant to raise any defences that they see fit. There is a defence called contributory negligence, which could be raised where the defendant may claim that the claimant contributed to that breach of duty. So this area, as you know, has been around for a long time, and it was formally recognised in Donoghue and Stevenson. So we're looking at around 100 years of this offence. But around the same time, the earlier case of Bateman, 1925, recognised that there could be instances where negligence could actually be criminal if it led to the death of somebody. And I've put the brief facts of Bateman here that you could write down. This was about a doctor who was deemed to have acted negligently during the delivery of a child, carried out an operation using considerable force, and the child actually died upon delivery. And Bateman was deemed to be criminally negligent for that and was charged and found guilty of the new concept of gross negligence manslaughter. As we've recognised before with the lawmaking powers of judges, judges can create offences. They can create precedents that then affect that defendant in the current case. If you think of Shaw v DPP, the creation of the offence to conspire to corrupt public morals, Shaw was found guilty of that offence as it was created in his case. So obviously that is a drawback of this system of lawmaking, but nevertheless it enables society to move forward. And I've put a summary of what was said in Bateman. So the court said, in order to establish criminal liability, the facts must be such that in the opinion of the jury, the negligence of the accused went beyond a mere matter of compensation between subjects and showed such disregard for the life and safety of others as to amount to a crime against the state and conduct deserving punishment. So this is a really interesting paragraph of how the courts determine negligence to become a criminal offence of gross negligence manslaughter. So a couple of things to highlight. The opinion of the jury. It is for the jury to decide whether this is a criminal offence or not, which raises some criticism, obviously. Showing such disregard for the life and safety of others as to amount to a crime. So we're looking on the facts. Has what the defendant done, or failed to do rather, in their breach, showed such disregard for the life and safety of others? So we're not going to be concluding necessarily that a mistake would give rise to this offence, but something that has such disregard. Think about the Mick Philpott case, what he did, setting fire to the house, what Goodfellow did in the similar way. Those two defendants showed disregard for the life and safety of others. So it's easy to see, applying that, how they were guilty of gross negligence manslaughter. And then you had the later case of Adamaco, quite some time later actually, an anaesthetist who in their failing to observe a patient properly in the way that they would be expected to by their profession, that patient died, and Adamako was able to be convicted of gross negligence manslaughter, applying the principle from Bateman. Interesting that the two founding cases involve medical negligence. I'm going to move on to the requirements of this area. So the first one is a duty of care must be owed. So you have learnt these duties before, so hopefully you can complete these in your booklets, and you need to make sure that you can illustrate the relevant cases alongside these. So I'll take you through these now, and hopefully you can check them off and make sure you've got them. So you have the relationship duty, so making out a specific relationship, and that tends to be a familial relationship, so mother or father and child, siblings, and that comes from Gibbons and Proctor. Contractual duty, so through a contract of employment we can make out a duty. Doctor to patient, Adamako. And of course Pitwood is a good illustration of that as well, who failed in his duty at work. A voluntary duty, and that comes from Stone and Dobinson, so where you volunteer to take care for somebody. Public office, and that's Dytham, if you remember the police officer. So anybody in the emergency or public services would come under that bracket. Statutory duty imposed by Parliament. A good illustration of that is the Road Traffic Act, somebody who fails in their duty as a competent road user. A dangerous situation, so creation of a dangerous situation. You've got Miller or Santa Bermudez. You might remember Santa Bermudez being the defendant who failed to warn a police officer that he had a needle in his pocket, and when the police officer searched him, she became injured, ABH injuries, and the defendant in that case was deemed to have failed in their duty. And finally, the newer duty, a duty to mitigate harm and save life. Be careful where you're applying this, because it is relatively new. It's unclear how far this extends, but we know from Evans that this extended to an extended familial relationship, so the half siblings, a mother, and of course that was a failure to gain help from the emergency services when the victim was overdosing. Secondly, quite a lot to say in this slide, so do please take your time and pause and write notes. So there must be a breach of that duty. So I've put the key rules at the top. So in determining whether somebody has breached the duty of care, you have to compare them to a similar person in the field. I said to some students in the class last week that this could even be, let's say you have two gardeners and one has failed in their duty. You compare that gardener to a competent gardener. How would they have acted? So any type of role that somebody is playing, compare them to another competent person in that same role. So the defendant's behaviour is judged against the competent, reasonable person. If this is a professional, then we judge them against the standards expected of that professional. Now, every professional is judged against particular standards. If you think solicitors are regulated by the Solicitors Regulation Authority, barristers are regulated by the Bar Standards Board, these regulatory bodies set the standards by which we are judged. So any court, in determining whether a solicitor or barrister has breached their duty, would compare them against the standards from that regulatory body. And it's the same with medical professionals, and Bolam is a good example of this. The full citation of that case is Bolam v. Friern, that's F-R-I-E-R-N, Management Hospital. And this was in 1957, so the claimant was a patient undergoing electroconvulsive therapy to treat his mental illness. Now, the doctor, Bolam, in that instance, was meant to give him a relaxant to make sure he didn't cause any injuries whilst undergoing this therapy. Interesting, 1957, that's the way they're treating mental illness. And the claimant suffered a serious fracture because he wasn't given this relaxant. Now, actually, in the end, Bolam was not found liable, not in breach of his duty, but the court did take the opportunity to satisfy the test. And they said the test is that the defendant will be judged on whether they acted in accordance with the standards of the professional body. So this would be the General Medical Council for medical professionals. There is a further case called Montgomery v Lanarkshire Health Board. It's a really sad case because it involves a baby dying during delivery. But this case takes this judgment one step further as to in any medical situation, the court will also want to know what the patient's needs were and how much or to what extent the patient was informed. So it could be in this case that had Bolam had consulted with the claimant would have said, I want to have the muscle relaxant, or they might have said, I don't want to have it, in which case that would have an impact on whether Bolam had breached their duty or not. So, and of course this would be more relevant if you have an adult patient who is able to be informed about their own decisions. And if you read the Montgomery case, it is relatively recent, so last 10 years. The patient there was due to give birth to her child and she wasn't given the option of a caesarean section. She had complications. Had she have been given the option, she would have opted for it because consequently she lost her baby during natural delivery. So really, really sad, and that's what the courts will also take into account. But we will come to that when we look at this in more detail during your tort lessons. So for the purposes of the criminal offence, we are purely judging the professional against the standards expected of them by their professional body. Would a doctor be expected to act in this way? Equally, if you have an amateur, so somebody who isn't a professional, perhaps they're a learner, like in Nettleship and Weston, we had a learner driver who was being taught by a neighbour friend, and they actually crashed into a pole and fractured their friend's knee. And when their friend tried to claim compensation, interestingly, the learner driver argued, well, I'm a learner, and also my friend is contributing to this negligence. They also raised a defence of consent and said, well, my friend was consenting to being in the car with me. They knew the risks. The court did accept contributory negligence, but they did, and this is the important part, they judged the learner driver against the standards of a competent driver. So just something to take into account. Even if you are new at something or you're learning something, you are judged against the standards of the competent person in that field. So it's quite a high level test there, open to some criticism. So because this is a criminal area, I've given you also on this slide some criminal examples of breaches. So you've got the case of Khan and Khan, two defendants, Khan and Khan, who left a 15-year-old girl overdosing in their flat on heroin they had sold to her. They, on the evidence, they could see that she was suffering an overdose and they failed to gain help for her. So they were deemed to be grossly negligent and therefore guilty of her manslaughter. And the case of Wacker, a lorry driver who carried 60 illegal Chinese immigrants. Now, he had warned them that if the air ventilator needed to be shut, that meant that they needed to be quiet. So there was obviously authorities nearby. So when he shut the air ventilator, they didn't make a sound, but he failed to reopen it, and 58 of them actually died. Now, he tried to raise a defence at trial, and it's called ex turpi causa. Now, what it means is that it derives from civil law, and what it actually means is that a claim for negligence shouldn't succeed if it's in connection with your own illegal act. And of course here the Chinese immigrants were themselves committing an illegal act, so therefore usually those family members or the two that survived who were trying to claim compensation and trying to claim negligence wouldn't be able to succeed. But the court here, given that so many of them died in such negligent circumstances, didn't allow Wacker that defence, and they found him guilty of gross negligence manslaughter. So a really interesting case to look at. So in summary, where we've established a duty, we then need to decide whether that duty has been breached. You consider who the defendant is, what their role is, and you judge them against the competent person in that particular field. And if you can, you use the criminal examples to make sure that you're citing relevant law here. Okay, so there must be a breach of duty. And how we determine that is on the facts. Has the defendant fallen below the standard of care? So I hope that makes sense. An added layer which makes this a criminal matter, because of course owing a duty and breaching that duty is still the same requirements for the tort of negligence in civil law. The breach must be gross, and Misra and Srivastava, again, two doctors, is a really good illustration of this. Now, two doctors who were convicted of gross negligence manslaughter, they tried to appeal on the basis that this area of law was unfair and in breach of their human rights. They tried to argue that the creation of this offence based on negligent principles, and actually putting that decision in the hands of a jury to decide whether it was criminal, was actually in breach of their human rights. They were unsuccessful, but it's really interesting to note that many people do criticise this offence and whether it should actually be in action or not. And where we're talking about criticisms and evaluation, make sure that you make a note of these, because these are all relevant for an essay to evaluate this area. So from Misra, the doctor's contention wasn't just rejected, but there was a bit more clarity about what should be considered as criminal to turn this from a civil offence to a criminal offence of gross negligence. Think of it as an added layer. And the question is whether the conduct has fallen so far below the standard expected that there is a risk of death. So when you're considering, or you've decided that there is a breach of duty, you need to then decide, is this criminal? Is there a disregard for the safety of life? Is there a risk of death? And that will really help you factually to decide whether somebody should be guilty of this criminal offence rather than just the civil offence. So of course, as I said, there is a criticism here because this is in the hands of the jury. We know, going back to the role of a jury, that they are deciders of fact rather than law, and arguably this principle is requiring them, or this offence is requiring them to decide the law in addition. Okay, and then finally, the breach must cause the death. So remember, these are result crimes, so we have to make sure that we have established causation. So your usual rules, but for the defendant's actions, would the victim have died? And were the defendant's actions more than the minimal cause. And of course, our intervening acts will still apply. So you have the unreasonable actions of the victim, unreasonable actions of third parties, and palpably wrong medical treatment. Now, medical treatment could be the main focus of a gross negligence manslaughter scenario, because of course it's founded upon negligent doctors. So just be aware of that and make sure you're clear who the parties are in a scenario so that you don't get confused. It used to be the case more where we had longer 50 mark scenarios with OCR, used to get quite confusing, but with a 25 mark it is clearer, and the questions seem to be more specific, which I'll talk to you about in a bit more detail. So what the law says about medical treatment intervening and breaking the chain, it will only break the chain if it is palpably wrong and so potent in causing death that it is independent of the original defendant's actions. And remember, that comes from Cheshire. Okay. So I have put a summary here for you of gross negligence, the AO1. So make sure you take some time to write that down. Some of you already have this. So we have the test set for this new, I say new offence, but new criminal offence based on civil principles. You have the owing of a duty of care. You have the breach of the duty. The breach must be gross. And then the breach must cause death. And I've just put a final note at the bottom here. As a matter of policy, gross negligence manslaughter is more likely to be the charge for deaths relating to the supply of drugs. So with unlawful act manslaughter, in part 1 we talked a lot about the supply of drugs and what would result in a defendant who supplied the drugs being liable for the death of the victim who overdoses as well. Where we have deaths relating to the supply of drugs, the Court of Appeal said in Diaz and confirmed in Evans that gross negligence manslaughter should be the more likely charge. So just be aware of that if a question is open and requires you to consider what the type of involuntary manslaughter would be, then use that as your go-to first if it is a drugs style set of facts. But with the new style OCR questions, they tend to be more specific, so you shouldn't have to make that decision, but if you do, just be aware of that. Okay, so make sure you write that out, and when you start practicing, you can use this template to state and apply. So what is the duty of care? Is there a breach? Is it gross? Has it caused the death? Each layer you are stating and applying to the facts of the scenario. Don't be afraid to use paragraphs and headings as well. Makes it all clearer for us. So reckless manslaughter, the final type, not a lot to say, one slide here, because it is purely based on recklessness. So we have the defendant that's committed an act, or, note I've put here, omission. So this is quite wide in that you could, as a defendant, commit an act or fail to commit an act which causes death. But the key thing that makes this, or would make this reckless manslaughter, would be that as the defendant you have to be aware of a risk and take that risk without justification. Now that's very different to unlawful act manslaughter, because there is no requirement that the defendant is aware of a risk. So this is, if you like, an added layer. And that's why I believe the Court of Appeal in Lidar said that this offence should stay. They believe that there is a place for this type of manslaughter with cases. So Lidar is a really interesting case, and I've put a link here if you want to read the actual judgment. It is attached to this law teacher website. So a summary of the facts are: a group of men had a row at a pub. It continued outside, and Lidar, together with friends, was in his Range Rover, so they were about to go. The victim continued to argue with Lidar through a passenger window, and Lidar drove off. Now, he argued at trial that he went to drive off because he was trying to defend himself, so he raised self-defence. He also raised necessity as a defence as well. So he started to drive off. His friends all backed his testimony and said that he drove off slowly and there wasn't a risk to the victim, but it appears that there was, because the victim was still halfway in the car, so leaning through the window fighting with Lidar, and because Lidar drove off whilst the victim was still through the car, the victim was pulled under the car and crushed and died. Now, Lidar was convicted at trial and went to appeal, and the Court of Appeal did reject his defences. They rejected self-defence, they rejected necessity, and they upheld the justification of keeping reckless manslaughter as an offence. So he was guilty. It'd be really useful for you to read the transcript and see what the judges said. But essentially, we could split this into three. And we could identify the act or omission, identify the defendant was aware of a risk, so he is reckless. If you think that the principle comes from the case of Cunningham, which sets the test for recklessness, if you remember, 1957. And then finally, the defendant has caused death. So you could split this into three. It's less likely to be a feature of a question in its own right, in its entirety, but you would gain extra marks if you believe that this could be an alternative offence charge. So do write no more than a sentence or two in a scenario if you believe that this could be relevant. Okay, so this is a scenario that I wanted you to have a go at. It's on your planners. And part of this scenario would give rise to gross negligence manslaughter, and that being the part of liability for Dr. Teal. So I've highlighted the part in red. Dr. Teal, who has been on duty for 18 hours, examines Donald and says he needs an urgent blood transfusion to save his life. Donald has a rare blood condition, but Dr. Teal does not check for this. Donald is given the wrong blood and dies. So we need to, and the actual question in the exam paper, and if any of you would like to see that, please do email me, I'll send it to you. Part of it asks you to identify or advise on Dr. Teal's liability for gross negligence manslaughter of Donald. And this is how I would set out this answer. So I would identify that Dr. Teal owes a contractual duty of care to Donald through doctor-patient relationship. Some of you who have been looking at this question have cited the duty to mitigate harm and save lives. Whilst that's not necessarily incorrect, first and foremost, Dr. Teal has a contractual duty through his employment, so do make sure you identify that. He breaches his duty, he falls below the standard expected of a competent professional in his field, and that comes from Bolan, remember. Applying it, he does this when he fails to check Donald's blood type, which should be a standard and necessary procedure for a blood transfusion. Whether the breach is gross, we identify whether there is a risk of death, so there clearly is a risk of death in his failure from MISRA. But is it criminal? Is it enough to charge him with gross negligence manslaughter? And we have to look at the facts. Why did he make this mistake? This is because he's been working a long shift, 18 hours, which is more than the average person would expect to work. So it may be that a jury would consider this is not a gross breach, and therefore he may not actually be liable. we can still go on to satisfy the final part, which is that he has caused the death of Donald, of course. But for his actions, Donald wouldn't have died, and his actions are more than the minimal cause. Remember, you only need to contribute to the death, you don't need to be the main cause. So we know there are other people that are also going to be liable for Donald's death too, but we are answering the question. So just make that judgment on the facts. Why has the defendant failed in their duty? And the facts of scenarios will give you that reason, so use it and make that judgment. Interestingly, with this scenario, you could have gone either way, so often mark schemes will give you the alternatives. So you could have considered that despite him being on duty for a long time, this was a basic standard procedure expected of all doctors. If you're going to carry out a blood transfusion, you should check the blood type, so therefore he would be guilty. So you could have concluded the other way. So don't be swayed too much about what will the examiners be thinking or what should I write. Be confident in your judgment on the facts. And you could give an alternative if you feel that would be safer. The other scenarios I've given you to practice, just wanted to take you through some of these. So you've got this scenario to practice also, and there is a relevant gross negligence manslaughter part with Jenny, who is a medical student. So we have Jenny, a medical student, decides that Thomas urgently needs a shot of adrenaline into his heart. She calls a more senior doctor but gets no reply. In her rush to help, Jenny injects the adrenaline into Thomas's lung. Thomas dies a few minutes later. So in identifying the duty, she owes a contractual duty. She is a student doctor, but I recognise that she tries to discharge her duty by calling for help, but obviously is unable to. So when she then decides to continue, she arguably goes beyond her duty here, which would be a breach. If you're a student, a medical student, you understand what you should and shouldn't be doing. The breach is gross because there is a risk of death. Whether it's criminal, the jury may not find it criminal because they might think, well, she did her best in the situation. Had she not have acted, she might have equally found herself in a similar position. So it's just interesting to bring in the jury's view on this, what you believe they may decide. Of course, Jenny's actions did cause the death of Thomas, so you could apply the but for and the more than minimal test there. You could be credited for a discussion of reckless manslaughter for Jenny here. So are her actions reckless? She realises there's a risk of harm, but in terms of taking that risk without justification, the CPS may fail here in proving that part because, of course, she could be justified by saying, I couldn't get help, so I had to act. All the doctors are busy at that time. Okay, so it would be good for you to practice one yourselves, and there is another application task in the booklet. This was the question on the right on the old OCR specs. You can see how complex previous scenarios used to be. This is about deciding individually 3 defendants whether they're liable for the death of Malik. So you split them up into 3. That would be the easiest way to do it and deal with one at a time. Try not to get waylaid by other defendants. So the frame I would use for this question, I would first deal with Cyril's liability for the death of his brother, and this would be gross negligence manslaughter. George's liability for the death of Klaus, again gross negligence manslaughter. Dr. Malik's liability for the death of Klaus, gross negligence manslaughter again. Interestingly, I've reviewed the mark scheme. This is a June 2016 question, and the application is all about gross negligence manslaughter, but the students were required to identify that. They weren't told, as you see from the question at that time. So have a go at that, and you're welcome to send it to me for marking. So we're nearly there, finishing involuntary manslaughter. We need to cover evaluation, but it would be worth spending a few minutes just recapping fatal offences and doing that via a diagram so that you are clear. So before I finish, I'm just going to summarise. Remember, murder is the killing but with the intention to kill or cause serious harm. We could potentially apply one or two defences to a scenario where the defendant is killed and has the intention to kill, but for a reason that should partially excuse their liability. And that would be under the heading of voluntary manslaughter. So remember, voluntary is about you are intending to kill, but there is a reason that partially excuses. So we have the loss of control and diminished responsibility defences there. Involuntary manslaughter is the lower level where you kill but you have no intention to kill. And in actual fact, you could drop involuntary manslaughter down below there and have voluntary manslaughter up higher, because involuntary manslaughter is a lower level culpability. In the absence of intention to kill or cause serious harm, that would be the alternative charge. So I hope that helps, and see you for part 3.